should I be putting forth my version of events in a criminal case against me? I was recently having this discussion with a person whose mother is in jail, and when they moved a bail application before the concerned court, they said that the lawyer who filed this bail application said, let us not argue anything on the merits of the matter. Let us not put any stance as to our version of how things transpired in this situation where the mother is an accused person. And when I was discussing this with this client, I said that yes, it is not a bad strategy on most days to not do this if you are actually guilty, if you have actually committed the actions of which you are being accused of, and therefore you try to meddle around with it or say that no, this is not the actual version of things, there is something else. On a lot of occasions you can mess it up. But when I actually heard the entire story, I realized that the mother of this client, the person who is accused, who is in jail right now, has actually not committed any offense, but was actually a victim of getting roped in, despite being innocent, in committing a small part. But because there is no guilty intention, and there is a very good chance that they will be able to prove it, or at least convince the judge before whom this bail application is being filed, that this lady was not a perpetrator but just an unassuming accessory to the situation without any guilt of her own. And to this client, I explained that in their particular situation, of course, so then it becomes a situation to situation thing. But I would say on a lot of occasions, in the majority of the occasions, if you are innocent, especially, it makes a lot of sense for you to actually put forth your version, the correct version of things before the judge who is deciding the bail application, because the age-old concept that we are taught across law schools and which is barfed out in judgments all the time, which is innocent until proven guilty, is just there for the books and for the judgments of the Honorable Supreme Court and the High Courts of the country. The ground reality, the hard-hitting situation in the courts of law, wherever you go, on most occasions, is that you are presumed to be guilty until you are able to prove your innocence. And so therefore, you must try your level best to show everything as transparently as possible. Put your version of things before the court who is deciding your bail application on every step of the way. Try to pull up the investigating agency as well in all of their deficiencies with your bail application, with other applications that you can file for monitoring of investigation, for calling of records, whatever is needed to be done to get that relief of getting your client out on bail as soon as possible. You need to do this, you need to take the steps rather than just saying, I am innocent, I will abide by all conditions, bail not jail is the rule. This is not enough. You need to present your version of the facts as well on most days.